Mr. Guthrie.
My Lords, I wonder if I can ask you to go to page 28 of the record, electronic page 28, which is where the judge summarized the way in which he resolved the dispute. In effect, he found that section 11.5 of the Constitution was ambiguous as a result of the deeming provision. And we say that he was simply wrong about that. It's perfectly clear. And as a result, he felt able to interpret the Constitution according to the broad purposive construction referred to by Lord Wilberforce and Fisher. And we say that the door wasn't open for him to do that because there was no ambiguity and because the words are clear. And in contradistinction to a case like Fisher, it was necessary for him to add words which are simply not there and to add a category which was not included in the list. The other matters he referred to it at 1 and 2 relate to the concept of belonging. My Lords, I wonder if I can turn to that. In the laws of Bermuda, the Constitution is the only place where the word belonging is used. It appears nowhere else, but is found in both sections 11 and section 12, which your Lordships have already seen. They're at pages 146 to 148 under Divider 1. Again, looking at the judgment at first instance, we would take issue with what the judge said about belonging. First of all, if you go to page 20, he refers to the submissions which were made by counsel in the Fisher case in paragraph 16 at the very foot of the page. Quotes from the argument as follows. There was a series of constitutions in the 1960s. Some, for example Antigua, used the expression belonging to, and others, for example Jamaica, used citizens. The term used picked up terms in existing legislation, but in the case of Bermuda, the draftsman had to invent a list of persons belonging to Bermuda because they were not defined anywhere else. The judge said that submission was not contradicted, but it was not correct. Well, I submit that the judge was wrong when he said that. He founded that on what follows. As more recent decisions of the House of Lords and the United Kingdom Supreme Court, considered later, have acknowledged, belonging was a common law concept which had been established for centuries. Had the board had the benefit of submission setting out the law on this point correctly, it might have been more cautious in using the word defines. And he refers again to the concept of belonging in paragraph 27 of the judgment, where he says, Jonathan Crowe, Queen's Counsel, Counsel for the Secretary of State, this is in the Banku case, of course, submitted that the concept of belonger was a creature of legislation, had no independent existence in the common law, and could not found any legally enforceable right. The House unanimously rejected these submissions and held that the Chagos Islanders had a common law right of abode as a belonger, or as belongers to the islands. However, a majority held that this right could be and had been removed by statutory authority and rejected the submission of Sir Sidney Kentridge that the right was fundamental and indefeasible. The case of Banku, however, is summarized somewhat inaccurately in those passages we would submit. It appears, in fact, if you have the case, it's at Divider 20 on page 465 it starts. It does indeed refer to belongers, but nowhere is are the incidents of a belonger, so to speak, defined or set out. The rights which the courts held attached to the Chagossians were not based on some concept of belonging, but in fact on the English common law. And indeed, the word belongers seems really to have been used more as shorthand to describe the Chagossians and their situation than as any legal concept. You've seen the, I would say you've seen the main passages in the judgment of Lord Hoffman at page 537 to 538. I'm just looking for the passage which I think you'll probably recall, where he says that both the submissions of both sides are too extreme, but perhaps it's not necessary to go to that in particular. The passage which my learned friend
yes, it's paragraph 52 refers to the extreme arguments on both sides.
Yes, and I think I'm looking at paragraph 42 for the moment. Sir Sidney's proposition that the Crown does not have power to remove an island's right of abode in the territories, in my opinion, also too extreme, which I think is seems to be the important part of it. He advanced two reasons. The first was that a right of abode was a fundamental constitutional right. Then we go to Magna Carta, and I won't read the whole of those passages again because I saw them this morning. But what is perhaps important to recognise is that the right which was being explained was not a right which depended on a particular status of being a belonger, but a right which derived from the fact that that's where they had lived before they were expelled, because what we're talking about in this case is the actual expulsion of people from their homeland. And then the important passage at paragraph 42 and 43, emphasizing the words at the beginning of paragraph 43, but by the law of the land, which are in this context the significant words. It's then said in paragraph 44, at the end of that, no power on earth except the authority of Parliament can send any subject of England out of the land against his will, no, not even a criminal. That remains the law of England today. Banku effectively established that such rights as were found to exist were subject to the law of the land, including Parliament. And that is something which is also reflected in the minority judgments, and I can come and show you those matters. The issue in Banku was whether the right not to be expelled from the homeland could be taken away where there had been no act of Parliament and no recognizable law of the land to take the right away, because what was done in their case, and eventually found by the majority to have been satisfactory, was that they were expelled by prerogative act and not by act of Parliament or anything like it. And indeed, Lord Mance, I think in a short paragraph just after the paragraph which my learned friend took you to, it's electronic page 575, paragraph, you'll recall he read the paragraph at the top of the page. Presumably a colonial endorsement could only reveal they belonged to BIOT because there was no other British colony to which they could belong. Mr. Crow's submission that Chagossians had no common law right of abode in BIOT comes close to treating them as if they were aliens, and is one that I would reject. But he then goes on to say, that does not resolve this appeal because of Mr. Crow's further and principal submission that any common law right, BIOT, that Chagossians may have had could always be and was overridden and removed by Her Majesty in Council. This, Mr. Crowe submits, is what Section 9 of the BIOT Order 2004 on any view achieves. Within the United Kingdom, such a result could only be achieved by Parliament, whereas in territories such as BIOT, it is submitted the royal prerogative reigns unlimited in scope. So the issue effectively being decided was whether or not the rights which it was held existed could be removed by something less than an act of Parliament, by the prerogative, and only the prerogative, and indeed it was found that they could even be removed by the prerogative. In the present case, my lords, the restriction on Section 11.1 is contained in the Constitution of Bermuda itself, which is plainly a part of the law of the land, and indeed it is in fact the Constitution enacted by an act of the English Parliament, the United Kingdom Parliament. Your Lordships may have noticed on the first page of the extracts from the Constitution at Divider 1, reference on page 129 to the Bermuda Constitution Order having been made by Her Majesty in Council under the Bermuda Constitution Act, 1967, and that is indeed the case. I have got a copy of the Act available, which I can make available for your Lordships if you would wish. It's a very short Act. Yeah.
One of the shortest I think I've ever seen.
Oh, you're sorry. Yes. Well, some might say that was a good thing.
Indeed.
But what it effectively says is that the orders in council can be made in relation to the Constitution, and that it can be varied or revoked by a subsequent order in council, but otherwise can't be, and that any order in council which is concerned must be laid before Parliament after it is made. So it's difficult to see that the case of Banku really gets the appellant very far in this case, because it's authority for there being a right of abode and a right not to be expelled. But that authority is expressly subject to the law of the land. And in Bermuda, the law of the land is contained in the Constitution. The Constitution is authorized by Act of the United Kingdom Parliament. I would add that in any case, the common law rights which Banku confirms and holds to exist are not in the present case being contravened or threatened. As we know, Mr. Barbosa is a British overseas territory citizen by birth. As we know, he has indefinite leave to remain in Bermuda. As we know, he has a Bermudian passport. And those are at least as great as the rights which are held to exist in Banku. There's one short passage in Banku, my lords, I just ask you to look at very quickly. It's in the judgment of Lord Hoffman.
But I mean, surely if the common law rights exist, subjecting someone to a regime where they need permission to be there is an interference with those rights, because otherwise they would have the rights to be there without any intervention of a regulatory authority.
Well, one has to look at the realities of this situation. This is why I'm taking you to the short point of Lord Hoffman, where he talks about what is really at stake in the Banku case, page 540. And he cites on page, it's the top part of page, in the paragraph 52, Sir Sidney having submitted that there should be a strict construction of the position, where a measure affects fundamental rights, the courts will employ an anxious degree of scrutiny in requiring the public body in question to demonstrate the most compelling justifications existed. Wouldn't disagree with that. I think it is very important in deciding whether a measure affects fundamental rights or has profoundly intrusive effects, one consider what those rights and effects actually are. And the fact is that Mr. Barbosa is living in Bermuda. He has, it's certainly the case that it's an anomaly, as both the courts below noticed, that he has, so to speak, lesser rights than his wife does. But the fact is that he still has the protection of Section 11, subsection 1, which is not completely removed by Section 11, 2D. They can only be taken away by law. And his right of abode, as a matter of fact, is it's where he lives, and no one has threatened to remove him.
Mr. Guthrie, we're looking at the construction of this constitution made many years ago and before Mr. Barbosa was born. I've had a brief look at Part 3 of the Bermuda Immigration and Protection Act 1956, which sets out how you acquire status in Bermuda. And it seems that the real problem, the real anomaly here, is that you can only get status by birth if one of your parents was also Bermudian. So can I ask you to posit a person who had, many years before the Constitution was enacted, been born in Bermuda, but neither of whose parents were Bermudian, and who had not got indefinite leave to remain by the time the Constitution was enacted. Now, firstly, would he owe allegiance to the Crown in its... He'd always lived in Bermuda, be born there. Would he owe allegiance to the Crown in its capacity as sovereign of Bermuda? One's tempted to think he would do.
There's some very difficult law on that. I certainly looked at in the case of William Joyce.
Yes. Yes.
William Joyce, Lord Haw-Haw.
Oh, Lord Haw-Haw, yes. Well, but I think there's been a lot of complaining about what happened to him.
Yeah. Well, it was a rather contrived argument to bring him within the scope of owing allegiance to the Crown.
Yes. But he was Irish.
Yeah.
Yes.
So he wasn't within a...
I don't think he'd been born in... Was he born in the UK?
Well, I think he was born at the time of his birth. Ireland would have been part of the United Kingdom.
Yes.
Yeah, and during the
Yes.
I think it was based largely on a false statement he made in an application for a passport.
Yes, yes.
But the reasoning in the Queen and Joyce was perhaps suspect.
Yes.
May not be the most reliable.
My only point is that these are deep waters.
Yes.
Yes.
The reason for my question is that if the answer to that were yes, and I appreciate it's deep water, then the concomitant duty of protection would arise, and it's difficult to understand in relation to where, other than Bermuda, that duty of protection would have practical effect, for the reasons set out, I think, by Lord Mance, isn't it, in Bangkok?
We know that he is, in fact, not a stateless person.
No.
Because he's got British citizenship.
So I'm not looking
Portuguese.
I'm not looking at the statelessness.
So he's not the Flying Dutchman.
No.
Lord Sadler-Best has just passed me a section which may assist in this.
I mean, he is, of course, he was, of course, in this analysis, whatever the predecessor of the British Overseas Territories citizen.
I just have a moment.
Yes, certainly.
Yeah.
Yes.
But if either for that reason or because he would have been under this analysis before the renaming a British Overseas Territories citizen, if for any of those reasons he owed allegiance and the concomitant duty of protection existed prior to the passing of the Constitution, then is there not at least an appearance of taking away in relation to such a person of the common law consequences of being entitled to that protection owed by the Constitution construed in the way which you seek to construe it?
Well, we only get into that territory if the Constitution is not clear.
Granted all that.
Yes.
Yes, I'm not on the clarity.
My principal point is that it's so clear that we don't need to get into such.
I understand.
And I have to admit that your Lordship's question is not one which I had prepared an answer to. So, but it may be that the suggestion is that the allegiance would be owed to Her Majesty rather than to Bermuda.
Well, it would be to Her Majesty in right of Bermuda, wouldn't it?
Yes, as sovereign of Bermuda.
And what protection is Mr. Barbosa entitled to in return for that allegiance?
Well, well, again, I think I fall back on my principal point, is that the words of the Constitution are so clear as to... and indeed, running through this one, I haven't disputed or sought to argue with the conclusions of both judges below that this produces an anomalous situation.
I'm sorry.
This produces an anomalous... I'm sorry. I haven't sought to really complain about the findings of the judges below, that this produces a somewhat anomalous situation. I think my learned friend said that we accepted it was anomalous and unfair. Well, that may be true to an extent. I think the degree of unfairness is perhaps something we would not be ad idem about, because, as I've already pointed out, Mr. Barbosa does have indefinite right to remain and so forth.
I'm thinking not so much of anomaly or fairness, but the invasion of a fundamental pre-existing right.
Well, I'm not sure I've got an immediate answer to that. The fact, I still maintain my position that there is still some protection granted to Mr. Barbosa by Section 11.1, which is not rendered entirely nugatory by Section 11.2d. And it's perhaps worth just looking at the way in which this case developed.
Just before you move away from the anomalous situation of the wife, what do you say about the possibility of Mr. Barbosa obtaining naturalisation in such a manner as to bring himself within the definition of Section 11?
Well, I don't think I can add to what Mr. Sanderson said. I mean, I don't think he can do both. He can't be a British overseas BATC by birth and apply from that situation to become...
The suggestion was that it might be possible for him to disclaim his existing British overseas citizenship and then reapply.
Well, I suspect...
That might be unattractive for various reasons, but is that a possibility?
It may well be possible if he... I imagine that he would have certain assurances from the government as a result of his application before he made it. But if I can just continue on the anomalous point, the question is what can be done about it in the face of clear constitutional provisions. If the situation gives rise to such an anomaly, then the remedy is not to say that the Constitution means something that it doesn't mean. The remedy is to either amend the Constitution or, alternatively, amend the underlying immigration legislation to alter the definitions of Bermudian status. But what I would respectfully submit your lordships can't do is simply say that although the Constitution clearly means what it does, it has to be interpreted to mean something that it clearly does not mean. effectively what the judge did by making a declaration that Mr. Barbosa was a belonger for the purposes of Section 11. He is driving a coach and horses between Section 11.5, through Section 11.5, which is not something which a court can do unless it can find some ambiguity or some basis for reading the Constitution as meaning something which apparently it doesn't, or expanding its, or saying that it does in fact mean what is suggested. I mean, that can be done in Fisher because child can be found to mean illegitimate child as well as legitimate child, but it can't be done to say that a naturalized BOTC includes a BOTC by birth, because it doesn't. Mr. Barbosa doesn't fall within Section 11.5b. The question might be, I mean, asking us rhetorically, what sort of order could the court legitimately make if, as we say is correct, the sections of the Constitution are perfectly clear, other than drawing attention to the difficulty? Surely it must be left to the legislature to put it right.
Yes. I mean, as a son of Portuguese parents, Mr. Barbosa wouldn't have been a British subject under the 1914 Act, but he would be under and was under the 1948 Act by reason of his having been born in a British colony. The position would have been different, obviously, if he'd been born in the Azores, for example. Yes. Yeah. Yeah.
But is one not left? My own friend fairly said one always comes back to the same point. Can you read Section 11.5 in some way as including a person in Mr. Barbosa's situation? Mm-hmm. And I would respectfully, Section 11 as a whole, I would respectfully submit you simply can't. And that was recognized by the Court of Appeal. And the reasons that the judge found for saying that you can are plainly not right. There is no ambiguity in it. Construction.
I mean, there is a sort of definitional issue if you try to go beyond Section 11.5. If Mr. Barbosa qualified for as a national of the United or citizen of the United Kingdom and colonies because he happened to be born in Bermuda. There would be other people who qualified because they happened to be born in the Azores to British parents, or maybe just a British father, in fact. And you have to, so that would be somebody who might, for example, be living in Bermuda, but had been born in France, say, to a British father. Is he to be a belonger?
Well, only if he comes within section the list.
Yes, well, that's really the point I'm posing. That if once you open the door beyond Section 11.5, there's a question.
Yes, or who can walk through it?
Who can walk through it? Yeah.
Well, again, I would have thought, and I very respectfully submit that is a risk which your lordships ought to be reluctant to run.
Yeah.
If the consequences are not clear. I mean, I heard Mr. Sanderson say that it was thought that some 300 people might be affected, but I wonder if see what the effect of an order would be. Indeed, in my respectful expression, it's rather difficult to see what sort of order your lordships would think ought to be made in relation to the originating motion, because this is a matter I wanted to refer to your lordships. The way in which this case develops...
Before you move on, the situation postulated by my Lord Reed does not, of the person who's born of British parents in France and then is found in Bermuda, does not have the feature which exists in the case of Mr. Barbosa, that he enjoys his British overseas citizenship by virtue of his birth in that particular territory.
further difficulty in the way of...
Well, it may be an important distinguishing feature from the other situations which might have to be addressed if the list in subsection 5 of section 11 is not comprehensive.
So I mean, just pushing the point, one could say, well, the door opens to people who qualify for citizenship under the British Nationality Act 1948, section 4, by virtue of birth in Bermuda. Now, if one then starts looking at what about people who were born before the British Nationality Act of 1948, were then in the territory of British subjects under the 1914 Act, and I suppose you would again have to restrict it to, or would one, to people who are British subjects by, well, mind you, their birth in Bermuda wouldn't be enough. You would have to be born to a British father, I think, in Bermuda.
Before 1948, it would have depended on the parents,
Yes.
not on the place of birth. Yes.
Yes, that's right.
See,
And
But
indeed, status in Bermuda still does, apparently. Has to be one Bermudian parent for birth in Bermuda to give you status.
yes, I believe that's right. Yeah. Well, this really, I would respectfully submit, serves to underline the risks involved in this case by saying that the list in section 11.5 is anything other than exhaustive, which, as you know,
Yeah.
say very definitely.
Yes, it would have to be any person born within His Majesty's dominions and allegiance, provided the relevant part of the dominions where he was born was Bermuda. So really, once you open the door, the court is having to effectively define different categories by reference to legislation which applies to that particular individual prior to the Constitution of 1968.
The problem is avoided if the section means what it says. But I was just, the only matter...
Can I just, since we're debating that, it seems to me improbable that some of these questions, at least, would not have been addressed in the Constitutional Convention. So can we put a plea through to you as representing the government?
Well, we've done our very best on the internet, as you can imagine, but so far without very much success. But we will do that. I was only going to highlight one matter as to really particular to these proceedings, because we're talking about Chapter 1 of the Constitution, of the Fundamental Rights Provisions. The way in which the proceedings came into being appears from the originating motion, which is in the record towards the beginning, I think it's page 10. And it's apparent that this question of belonging or not belonging really arose in almost by a side wind, really, because if you look on page 10, you'll see that the first point that was being sought, the second appellant, that's Mrs. Barbosa, was asking for a declaration as a person who belongs to Bermuda. She certainly does, and has the right to reside in Bermuda without discrimination. That her and her husband should be classed as being residents of Bermuda for the purposes of the Adoption of Children Act. And then the first applicant, Mr. Barbosa, seeks a declaration that as a BOT citizen by birth, he belongs, on the basis that although Section 11.5 provides a list of persons deemed, this only complements rather than excludes. And then it says, if such declaration is granted, he accordingly seeks the same relief as that sought by the second applicant. So the application in relation to Section 11 was really being used as the basis to launch, first of all, the adoption point and the discrimination point related to the adoption point. And then over the page on page 11.
But sorry, in what sense is that a sidewind? It's a necessary foundation.
Yes, well, I used the wrong word. Sidewind isn't the right word. But it was the purpose of Section 11 was not to allege a, so to speak, freestanding breach of that section, but in order to establish a foundation for a claim under the Constitution on the basis of discrimination related to the adoption application, and in 3 over the next page, as a basis for a claim that he had been, as a result, he was subjected to inhuman and degrading treatment, which has gone. But I'm really using this to distinguish Mr. Barbosa's situation from, say, the Chagossians, who had a freestanding claim equivalent to the breach of the Constitution for being expelled from their homeland. And under Section 15 of the Bermudian Constitution, which is under Divider 1 at page 152, the right to bring constitutional proceedings, Section 15.1, depends upon the fundamental right relied on having been, or as being, or is likely to be contravened in relation to that person. And in contradiction to, say, the Chagossians, no one has sought to expel Mr. Barbosa or to interfere with his rights under Section 11.1.
But
this is
to go back to my Lord Sales's point earlier this afternoon, the issue before us could just as easily have been raised by an application for a declaration that requiring him to obtain leave to remain was a violation of the rights he enjoyed under.
But that is, as a matter of fact,
right.
not what has happened. And it may be that, and I'm certainly not suggesting that he hasn't any right to be here. I'm just underlining the point that in his case, the breaches of Section 11.1 are hypothetical because they were not in existence unless and until someone interferes with his right of abode or...
Well, in a sense, that interference has already taken place by the government saying, we're only going to let you be here if you've got permission from us. All right, we'll give you the permission, but we're still saying you don't have the right.
Well, I mean, he has, as I say, the right of abode is implicit, is it not, in the right of indefinite leave to remain?
No, because if he doesn't need leave, if he's got a right.
There may be all sorts of circumstances in which right to remain can be removed, where a right to abode could not be.
Yeah.
Submission, I think it's probably fallen on stony ground. Yeah. My Lords, I haven't any further submissions to make.
Thank you very much, Mr. Guthrie. Ms. Sadler-Best, is there anything you wish to add?
Not quite, my lord. I was only referring to the point of in any event.
Yes.
The responsibility for defense does not rest with the Bermuda government. It still rests with the government in place of the United States.
Yes.
And that extends in the Constitution to all persons, even resident in Bermuda. So it doesn't only extend to persons born in Bermuda.
Yes. Thank you very much. Mr. Drabble.
My Lords, we have, I think, just obtained the report of the conference. And can I say at once that it was, as I understand it, looked at by both parties in the course of preparation for the Court of Appeal. So it's not as if I was completely ignorant about it, I own up to that, but it wasn't. As far as we consistently with what I was told over lunch, the Rome 1 provision that deals in the report with fundamental rights, I can read it. It's paragraph 32 of the report. We'll obviously make it available to you.
Is it paragraph?
32. But it says, the Constitution will make provision to safeguard fundamental rights and freedoms of the individual, whatever his race, place of origin, political opinions, colour, creed or sex, subject only to respect for the rights and freedoms of others and for the public interest. These rights and freedoms will include rights to life, liberty, security of the person, and enjoyment of the property and protection of law, and freedom of the conscience, of expression and assembly and association. The Constitution will also make provision to afford protection against discrimination on the grounds set out in the paragraph. Fundamental rights and freedoms protected in the Constitution will be enforceable, notwithstanding any local legislation inconsistent with them in the superior courts of Bermuda. That's it. So we are not getting, this is consistently what I've been told,
Yes.
any help on the issues which your lordships are debating. Obviously, we'll make the full report available, and no doubt...
And am I right in thinking then that the report appended to it what became the Constitution?
Yes. As I understand it, I've been
terms.
discussing with Mr Sanderson, obviously, about the way in which the Constitution is drafted, but there will be a template Constitution, because by the time you get to 1968, there have been several constitutions of this sort. So a draft would have been available before the conference. That will be debated. There are debates about matters such as the size of constituencies and issues of that sort. But there doesn't seem to have been, on anything I've seen so far, which is obviously limited, any debate about the scope of the people protected by Section 11 or matters of that sort. So we're not getting any help. Obviously, I regard it as my duty to make sure that is the position when I've seen all the material that's available, but that does seem to be the position. Now, a very limited number of other points then. The Lordships put to me section 102,
Yes, subsection 3.
5. 102(3) of the Constitution. I, of course, accept that if you look at any corpus of law, as wide as immigration or constitutional law, you will find the word deemed used from time to time. 102(3) is a perfectly orthodox use of the word deemed, meaning bring something in which might not otherwise bring in, because it's a provision against the removal of status when you had it at a given moment in time. So if you look at 3A, it provides, for the purpose of this Constitution, a person shall be deemed to possess Bermudian status in the case of a person who possesses that status on the date on which this Constitution comes into operation under the law then in force in Bermuda, if he has not lost that status under that law or any later law, amending or replacing that law, that is not less favourable to him. So it's deeming you to continue to have status, even though there might be a piece of legislation which on the face it removes it, unless that legislation is not less favourable to you. So that's much nearer, actually. If anything, it helps me. It's a reference to deeming in a much more orthodox way than Mr. Guthrie's use of the word deemed in 11.5. I actually submit it doesn't help at all. It just is a different context. I don't completely understand how 11.3a and b work, because I don't know what the concept of a law which is not less favourable actually means, if it's having the effect of removing status. But it's obviously something to do with entrenching the provision of status which exists either at the date of the Constitution or at some later date when you acquired it, and deeming it to continue. So it's, I just submit it does cast no light on 11.5. The only other matter that I would wish to address in reply is the discussion between your lordships and Mr. Guthrie about the outer limits of the concept. In other words, if it were right that Mr. Barbosa has something protected by the arguments in Banker, if I can put it like that, what are the outer limits? My primary submission is that your Lordship should not refuse to give Mr. Barbosa relief, effective relief, simply because there might be some uncertainties around the edges that can't be completely bottomed out. Lord Mance in Barbosa addressed this issue, a related issue, Your Lordships will go to Barbosa, which is in bundle 2, 521. Sorry, in Banku, I'm sorry.
Sorry, page?
I said 521, but I don't think that's...
No.
Must be internal 521. It's EB 574. And it's the tail end of 153. I think I drew attention to this before lunch. And the submission by Mr. Crowe is just above letter B. As to the latter, in any event, he submits, as Mr. Crowe, the concept of an inhabitant of Biot is too uncertain to receive legal recognition. As to the latter submission, there may be issues about who in and after 1965 was an inhabitant of the Biot, as opposed to an inhabitant of, say, Mauritius, or the Seychelles, working as temporary labour in Biot. However, it is clear that there were at least hundreds of persons who could only properly be described as Chargosians, even though they may have had no property rights in Biot as a matter of private law. Above all, it is, as Sir Sidney submitted, clear that Mr. Banker was a Chargosian by birth, and there was no difficulty in identifying the concept of a Chargosian for the purpose of the 2000 ordinance.
So can I ask, if Mr. Barbosa had been born in Bermuda, left the day after his birth, and yesterday applied to come back, would he be a belonger?
If he's a British, the answer I give to that is yes. So if he's a British overseas citizen by birth, he must have some, fundamental starting place of our submission. He must have there must be some territorial consequences of that citizenship. And the unit to which he belongs is the territory in which he acquired the citizenship.
That would be where he was born.
Which will be where he was born. Now, I can well see there might be more difficult issues, the pre-1948 Act cases and so on, but they're not directly in front of you. And my submission is that it would be unjust to deny Mr. Barbosa the consequence of the court's examination of his status as a British overseas citizen when he is in the clearers category for spelling out that consequence. Now, I want to be careful not to cut down anyone else's arguments. There will be people who've been naturalised by the governor they're in the list. But no doubt maybe other categories, probably small, of people who have the undeniable connection with Bermuda and nowhere else. That is the foundation of their British overseas citizenship, and I don't want to kind of be ruling them out. But we are in the situation where Mr. Barbosa's status is clear, on the line of my argument. The only way of defeating that is Mr. Guthrie's 11.5 just doesn't permit this interpretation, and for all the reasons we've given, it does. Indeed, I repeat the submission, it's actually the natural interpretation of the words used. It does use the word deemed. That's not an appropriate word for a definition section. It didn't matter if there are no other categories, but once you realise there are, then you've got to grapple with the consequence of the actual use of the language. Those, I think, are my submissions.
Yeah.
Would you permit Mr. Sadler-Best to answer Lord Sales's last question, which was as to...
Yes, well, if anything arises, no doubt Mr. Gravel can respond. Yes, Ms. Sadler-Best.
Thank you, my lord. In relation to the question of if Mr. Barbosa had been born in Bermuda, left the following day, and came back, yes, the answer isn't complete if you simply say he's a British overseas territory citizen. Because if I could just refer to the discussion that arose earlier about mapping citizenship onto a particular concept in Bermuda, it's clear from the entirety of the Constitution that those incidents of citizenship are mapped onto Bermudian status. However one might see the result of it in a particular case, the fact is that the citizenship that is attributed to a BOT citizen by birth is citizenship of Great Britain or the United Kingdom as a whole. And it's difficult to separate the concepts, I understand, but the Constitution is in 1968. The Bermuda Immigration and Protection Act is 1956. It's been amended several times, but that concept of status has been in there since 1956. And it's clear that some thought was put into, including a naturalized British Overseas Territory citizen in Section 11.5. The knowledge would have been there that persons possessed British Overseas Territory citizenship by birth, and it was quite clearly omitted. So in answer to that question, I would simply just submit that the fact of British Overseas Territory citizenship by birth is not synonymous to the concept of citizenship that has been used throughout my learned friend's submissions.
Yes.
Thank you.
Thank you very much. Yeah, can I just ask you, for the sake of completeness, really, the 1956 Immigration Act has, no, actually, it's the 1937. 1937 Immigration Act is referred to in the 1956 Act, and it seems to have been. It seems to have used the concept of domicile for the purposes of controlling immigration. Is that right?
Yes, that's my understanding, my lord. But the concept of domicile has proven very problematic in Bermuda because it's such a wide concept, and domicile by birth is difficult to prove that it has been abandoned.
Yes, I see. Thank you very much. Anything arising, Mr. Dremmel? Well, we're most grateful to counsel on both sides for their submissions. We'll take time to consider them, and in due course, we'll decide what advice we shall tender to Her Majesty. The court will adjourn.